Hi, Gaurav sir.
Hi, Rishman. How are you?
All well, sir. Thank you so very much, sir. Sir, very recently, the Honorable President of India has promulgated the Arbitration and Conciliation Amendment Ordinance of 2020. So, could you please help us understand what new sections or what new things does this ordinance bring into play?
Of course, Rishman. I'm thankful to lawyer to give me this opportunity. But before going to the ordinance, we need to understand the history of what an automatic stay means in the arbitration landscape. So, the 1996 Arbitration Act up until 2015 had provided the option or the opportunity of a party challenging the award to take an automatic stay. So, therefore, let's say I am an award holder. I have spent 5 years in arbitration. Now got an award. You can go to court, challenge it, and get a stay without paying or depositing anything. But
Right, sir.
that position changed in 2015. In 2015 Amendment Act, Section 36, Subclause 3 was also introduced, which basically introduced that the court can impose conditions before granting a stay. That is one. And the most important one was that the party challenging the award will have to make a specific application seeking stay of the award. Right.
Right, right,
But however, the amendment, you know how laws are made in the country at times, it was still silent. If this aspect of 36.3, the benefit will also be transferred or available to arbitrations or proceedings, case or court proceedings arising out of arbitration agreements prior to the cutoff date, that is October 2015. So this dispute, obviously, this issue raised a lot of hue and cry because people were confused with it. Even we were confused with it. So the Supreme Court, then in the case of Board of Control for Cricket in India, BCCI's judgment versus Kochi Cricket Board, clearly held that no automatic stay would be available on proceedings commenced even before the Amendment Act of 2015. It also upheld the provisions of Section 26 of the Amendment Act that provided for its prospective application. But the benefit that it gave, however, the Supreme Court also, so I feel that the Supreme Court corrected a long-standing wrong. So imagine from 1996 till 2015, there was a position of automatic stay. The 2015 Amendment Act gave very positive changes, but it failed to clarify the position. So the Supreme Court clarified that even if I want and a stay today for any proceeding that is initiated, let's say in 2011, the benefit of no automatic stay being granted against the award in my favor will flow down to me. That is a very positive impact that BCCI came forward with. However, then a expert committee was made. It is the report is called the Sri Krishna Committee report.
right.
That kind of discussed a lot of aspects, and in my opinion, it negated the benefit that was granted by the BCCI judgment. Now, based on that report, the government again came with an Amendment Act of 2019. As a result, they let go of Section 26 that was introduced by the 2015 Act, and they introduced a Section 87. I will refer to the basic clause of Section 87 that kind of lays down problems. So Section 87, Subclause 3 said that the application of the 2015 amendment will apply only to arbitral proceedings commenced on or after the commencement of the Arbitration Conciliation Amendment Act of 2015.
Right.
And also to the court proceedings arising out or in relation to the arbitration proceedings. Now, what effect did it have for a layman? Now, from 2015 onwards, when the BCCI judgment came in 2017, now I have the law in my favor. 2019, the government still goes back to the old position that the benefit cannot be granted to any arbitration proceeding or court proceedings arising out of an arbitration agreement that have been initiated prior to the cutoff date of October 2015. We refer it to as a cutoff date because it becomes easier for us to say it.
Right.
Then this obviously led to a huge challenge, and eventually it was challenged. This provision, Section 87, was challenged in the Supreme Court of India. And the judgment, the major judgment that came out of it is the judgment in which it was challenged is Hindustan Construction Company Limited versus Union of India. Now, this judgment was on two folds. One was a challenge of Section 87 and to challenge the repealing of Section 26, and the other part was on IBC. Today, we're not concerned about what changes it made to the IBC laws. The Hindustan Construction judgment, the Supreme Court clearly said that this kind of a law that has been introduced by the 2019 amendment again takes us back. It is a regressive position, and it is very special, I would say, a smart thing done by the government that without really challenging the basis of the judgment, they still negated the judgment of BCCI. Now, in Hindustan Construction Limited, the Supreme Court restored the position and laid down the law, clarified that the BCCI, the law laid on BCCI is upheld. Section 87 is invalid and Section 26 should be there. So basically, we went back to what the BCCI said. Now, if I would talk about the current ordinance that is there, right? So the current ordinance, what does it provide? So the BCCI and the Hindustan Construction basically laid down a law that no automatic stays should be provided to any person challenging an arbitral award. Now, the ordinance, the current ordinance that has just been promulgated yesterday, it says that parties get an opportunity to seek automatic stay of enforcement of arbitral awards where the underlying arbitration agreement, contract, or award itself has been obtained by inducement of fraud and corruption.
Okay.
So it does put down the aspect of that, yes, I can only obtain a stay when I can establish prima facie that the award or the arbitration agreement itself is perpetrated by fraud or corruption. But in my opinion, this is, again, it gives a very wide berth. It is up to lawyers and how do we present a case of fraud. A fraud can be very simple. Or let's give an example of corruption. You file a claim of ₹5, I file a counterclaim of ₹10, but the arbitrator gives an award in your favor or in my favor of ₹100. That's a clear-cut example of corruption in arbitral award. And it is very easy to establish this. I will not get into the dispute of complex or a simple fraud. That is for another time. But I feel that this amendment is not really a sound arbitration policy because this will make the enforcement difficult. Therefore, it has now created new hurdles and it goes against the sanctity or the position of the arbitration proceedings, which basically provide for a summary disposal or a faster mode of dispute resolution. And I'm still a little, divided as to whether it challenges the Hindustan Construction completely, because it kind of does not, because Hindustan Construction also did not deal with the partly honored arbitral awards, and neither does this new ordinance. So we'll have to wait for what happens on that front.
Right.
However, Section 43J, which is mentioned in the ordinance, it now says that this is repealed. It will be substituted. So basically, the 8th schedule of the Arbitration Act is omitted. This, in my opinion, is a very welcome step. It's a very positive step. This is about time that this was introduced. So the 8th schedule basically provides for qualification, experience, and norms for appointment and accreditation of arbitrators. So even if you're a deserving candidate to be accredited as an arbitrator, but because of the regressive policies made in the 8th schedule, you could not be appointed as one.
Right.
So doing away with this, I feel, is a very positive step, and I look forward to it. But at the end of the day, I feel that this ordinance will stand the test of time. So we'll have to see how it is challenged in court.
Absolutely, sir. Thank you so very much. This has been extremely, extremely helpful. I'm sure this is going to help our users navigate the ordinance much, much, much better.
Thank you.